Mr. McKevitt.
Will the sponsor yield for a few questions, please?
Mr. O'Donnell.
Certainly.
The New York State Constitution does not guarantee the right of same-sex couples to marry. Isn't that correct?
Well, that's a very interesting question. It certainly was the position I took when I was a plaintiff in a lawsuit that ended up in the Court of Appeals. 3 judges ruled that the Constitution did require me to be treated equally under the New York Constitution. 4 judges determined that I did not, and that is why they said that we needed to come to this body to change the domestic relations law to get that equality.
And the Court of Appeals essentially, in, I think it was the case of Hernandez versus Robles, which you were the plaintiff in, correct?
That's correct.
The court, what it said was, it wasn't going to be the dominion of the court, but it was then the dominion of this legislature to determine what the legal definition of marriage is, correct?
The argument that was placed in front of the judges at that time was that the equal protection and due process clauses of the New York State Constitution required that New York State issue licenses to its citizens equally under the law. That was the position I took. That was the position of the dissent. 4 of the 7 justices determined that in order to change the domestic relations law, that change needed to occur legislatively through this body. Yes.
Right. So it's a statutory determination, not one under the Equal Protection Clause of the Constitution. As the court determined, not that you agree with it, but that was the 4-3
That was the position of the majority. The position of the minority was that, in fact, and I bring that up to you because you always like to enjoy the fact that the minority should have more power. The minority position in this particular case was that, in fact, the Equal Protection Clause and due process clauses of the New York State Constitution required the state of New York's government to treat me equally under the law.
It is my understanding that there are approximately 1,324 rights that heterosexual married couples are entitled to that couples of the same sex are not entitled to because of the way the domestic relations law is written. Is that correct?
It's a number around there. If you're going to ask me to identify all 1,300, I cannot. But that's a number I've heard before.
That's a report that the Bar of the City of New York did a study, and they actually enumerated. They came up with the number 1,324. And they include such things as disinheritance rights, rights under the State Powers and Trust Law upon inheritance, spousal privilege. You know, certainly we're familiar with an evidentiary standard in a case. A spouse cannot be required to testify against each other. Those are rights that a same-sex couple cannot have because of the marriage laws that we have, correct?
That is correct, sir.
Okay. Isn't it possible then for us to write a statute, albeit a very long and very complicated statute, which can confer those rights upon same-sex couples?
I'm not sure I understand your question, so could you repeat it?
If there are 1,300 rights that same-sex couples cannot get the benefit from because of the way the marriage is defined under domestic relations law, we could write a statute, again, it'd be very long. I mean, we have budgets which are 5,000 pages long in this chamber, and say that each of those rights, for example, the inheritance rights, the rights of spousal immunity, every single one of those rights, we could then give that benefits to same-sex couples as well.
Well, I look forward to you drafting such a bill, and if you get all the members of your side to agree to it, it would be something that I'd be more than happy to consider. What you're basically saying is, why don't you make civil union the law in the state of New York, which is what was attempted in New Jersey. For a number of years in New Jersey, they had a civil union law. And what ended up happening was that the people who tried and thought they were getting those 1,300 some odd rights by getting a civil union turned out that they weren't able to really enforce those rights. And the area where it was most particularly a problem was when people were presented at an emergency room. When there was a car accident and there were 2 people in the car, and someone says to the attending doctor or the attending nurse or whoever else is there, well, I'm the domestic partner, I'm the civil union of the person who was injured, and they had no way to recognize what that meant. So essentially, in our culture, what we are seeking is the use of the term spouse. And the way you become a spouse under New York law is by getting a marriage license. Now, there was a proposal a number of years ago to eliminate spouses in New York law, and that would have made that everybody in the state was only entitled entitled to a civil union. But that didn't catch much steam, unfortunately, although I was willing to help in that effort. But that didn't get us very far. And so now, after going to the Court of Appeals, the only mechanism available for couples to get those 1,300 protections is for them to be spouses under New York law. And the way you become a spouse is you get a license by the state of New York.
So under the bill which you're proposing today, then a same-sex couple would be able to obtain the same type of marriage license that a heterosexual couple would receive from either a city or town clerk. Is that correct?
It is civil marriage alone. It is a license that is issued by the state of New York. That is correct.
Now, in the bill, there have been a number of exemptions that have been written into it regarding religious institutions. So is there anything in here which could possibly compel, whether it's a priest or a rabbi or a minister of a religion, which does not endorse marriage between same-sex couples, that would force them in order to go and perform such a ceremony?
Absolutely not. There is specific language that I demand to be included in the 2007 version of this bill, which clearly states that no religious person would be forced to solemnize the marriage. That clause has been retained from 2007 to 2009, and now in this particular version as well.
And the legislation also makes clear that you can't even bring a civil claim or cause of action against such a religious institution or a person for refusing to solemnize a marriage between two people of the same gender.
There is no requirement under this bill that any religious person is required to perform a marriage ceremony, and nor are they required to solemnize the marriage, nor the failure to solemnize would bring any cause of action. That is correct.
Okay. Also, another provision which I think has been amended in this bill from prior versions, which you talked about previously, are facilities which are run by maybe profit benevolent organizations, and whether they would be required to perform, let's say, receptions or ceremonies for a same-sex couple. Can you comment how the bill has specifically changed from what we've seen on 3 prior occasions?
Well, the law doesn't change. It just references what the law actually is. There is a provision in law that lists a whole bunch of organizations which are exempted from the public accommodations law. If you hold on just one second. It is a voluminous list. The American Hellenic Educational Progressive Association, the American Legion, American Vets, American Legion Auxiliary, the Ancient Order of Hibernians, the Benevolent and Protective Order of the Elks, the Fraternal Order of the Eagles, the Free and Accepted Masons, the Grand Army of the Republic, the Knights of Columbus, the Knights of Malta, the Knights of Pythias. There are a lot of knights. The Knights of Templar, the Order of Alhambra, the Order of America True Inverites, the Order of Amaranth, the Regular Veterans Association, the Jewish Veterans Association, the Catholic Veterans Association, just to name a few. All of those entities are currently exempted from the public accommodations law as written in statute. What has happened here in this version of the bill is that we reference those sections because people didn't apparently believe me last time when I told them they existed. So this time, we chose to put it in the language in the bill so it was clear that private institutions, and all of the ones that I mentioned have been deemed by this body to be such, are not subject to the public accommodations law. And therefore, they are free to do whatever they want as it relates to membership, as it refers to access and all those other things. Essentially, they are deemed under the law to be private. And so no one's required to throw a gay wedding.
So in order to be in that category, the list under the Benevolent Orders Law, under Section 2 and 7, you're right to give a very, very inclusive list of all these organizations. But if an organization is not on that list in that statute, then they cannot avail themselves of that advantage, correct?
Not true, young man,
Okay.
not true. In fact...
I'm glad you called me young man, so I'll take it.
Okay. If an entity meets the definition of being private, they are not currently allowed to be, they're not a public accommodation. So the question of whether, let's assume you wanted to form your own elk club tomorrow, right? If you formed your own L club tomorrow and it wasn't on the list of the approved L clubs that are exempt, if you meet the criteria that you are a private institution, then you are not required to be subject to the rules of the Public Accommodations Law. Now, that is true that that's a factual determination. And so there are instances where the factual determination, there may be a disagreement, but I'm pretty sure most of the ones that you would be thinking of would meet the definition of private under current law.
Your bill does go and exempt religious officials from being forced to go and solemnize ceremonies. But for example, let's say you have a town clerk or a city clerk or perhaps a judge, and for whatever personal reasons, they would not want to solemnize a marriage between couples of the same sex. Would they be open up to liability or charges that they are violating the law?
Well, that's a little bit more complicated to answer. For reasons that I don't really recall now, although I think I knew them better in 2009, the only people, no one is required to solemnize anything in New York. What we have here is the Department of Health chooses who the entity is that issues the licenses in different places. So let's assume that you and I wanted to get married, right? And we had a nice place. A girl can dream, Mr. McKevitt, what can I say? So we were going to get married, and we went to the county clerk in Columbia County. They issue a license to say you're allowed to get married. But that doesn't mean you're married yet. Right. You have to go and be solemnized by somebody else. And if you've ever been to a wedding, I've been to many gender discordant weddings, Mr. McKevitt, and at those weddings, they all end the same way. By the power vested in me by the state of New York, I hereby pronounce you husband and wife. It is the state that gives that power and authority. So that is the solemnization part. So no one in New York is required to solemnize marriages at all, except at the city clerk's office in the city of New York. And as best that I could figure out when I researched this in 2009, that came about for what we used to call shotgun weddings, right? So two people had a need to get married really quickly, and nobody would be willing to solemnize their relationship. So this body wrote into the law a very long time ago that the clerk of the city of New York, which is the issuing entity of the license, also can be asked to solemnize the marriage. That is the only place that that occurs. Obviously, there's not one person in the clerk's office who's eligible to do that in the city of New York. I know of nobody who's ever made a claim that they didn't against someone for their failure to do it. But the other people you mentioned, other judges or justices of the peace or those things, no, I do not believe that they are subject to any lawsuit for failure to solemnize.
And once more, is my understanding that under federal law, that even if New York State were to recognize marriages between couples of the same sex, they would still not be entitled to Social Security spousal benefits. Is that correct?
Yes, there was something called the Defense of Marriage Act, which is currently being challenged in the federal courts. In fact, I was told just yesterday that a bankruptcy court, I'm going to say in California, but don't quote me, has ruled provisions of DOMA unconstitutional. So yes, were I to get this license tomorrow, and I was subject, and DOMA still existed, it would not attach federal rights at this time.
Thank you.